All right. Good afternoon, everyone. We have, I didn't bring the calendar out. I brought a different thing out. Hold on one second. All right, I'm back. Okay, we have a calendar with two types of cases on it. Some are on for status, where I need to know what the heck is going on with the case. I have probably my 10th oldest case on here that's just sitting here. So if you're on for status, you're on to give me a real good reason as to why the case should remain open and what's going on with it. The other category of cases are defaults. And damages just weren't liquidated. So we'll need to be talking about what the damages are. I know some of you have sent in proposed orders, and it may be a pretty quick hearing, but those are the two reasons cases are on the calendar. And we're going to start just going in order on the calendar with Georgia Lottery versus Shiv 1965. This would be my really, really old case. Why is it still around? Who do we have for Georgia Lottery Corporation?
Your Honor, Ajay Harish for the plaintiff, Georgia Lottery.
Hey, Mr. Harish, how you doing?
Good. How are you, Your Honor?
I am okay. Do we have anyone for any of the defendants? It's a post-judgment case. It's actually the second iteration of the post-judgment case. Is Shardabin Patel around? Okay. Mr. Harish, tell me what's going on with the case.
So as you know, the court has already entered a $100,000 judgment against the defendant, but the defendant maintains that she's not the right person and that she's the victim of identity theft. So we took the deposition of who we believed to be her son, and his story was the same. So right now we're doing some investigation to determine if she's the right person. We have two different IDs for this defendant with different USCIS immigration numbers. So we've done a FOIA request under both of those numbers to see if we can glean some information to see if we have the right person.
These things that you've done, when have you done them?
The FOIA request was done last month, and for some reason there's been a delay on getting the response. I'm not really sure why, but I think I might need to follow up on that.
Okay.
The deposition was done in June, I believe.
All right. So this is a 2021 case that is sort of a renewal of a 2020 case that is built off of a judgment entered in 2019. Tell me why I should be optimistic that something is going to change in the next few months such that I should leave the case open.
Well, this is a case that I recently picked up from someone who used to work at the firm. I'm newer at the firm, so I'm optimistic that I'll be able to make something happen.
And the something that would happen would be through the FOIA request, you're going to figure out if, in fact, there is another Shardabin Patel or someone, in fact, hijacked the Shardabin Patel that you found's identity? Correct.
There should be another Shardabin Patel. If not, then I assume that we'll just have to dismiss this case. But if there is something from the FOIA request, then we'll probably have to try and enforce the judgment.
So I guess last question, I know you're new to the case, but I'm confused how identity theft comes into play. Presumably Shardabin Patel was the owner of the Co-Am operator location, Rabbit Truck Station. So I mean, it's real estate, it's a real person, et cetera. How is it persuasive to you, this notion that, oh, someone stole my identity? I mean, I would get that if we were dealing with a credit card account or something like that. But this is someone who ran a convenience store and sold lottery tickets and didn't send the proceeds back or put them in the right account. And Georgia Lottery got a meaningful judgment against them.
Right. I guess that's the thing. It's not really persuasive to me, and that's why we're doing FOIA request. I do believe we have the right person, but it's only a matter of going through the process to determine that.
Okay. So Blaine Allen is no longer on the case?
Correct.
And you are. How much time do you want to take whatever these next steps are?
It shouldn't take that much longer. What's the upper limit?
Well, I'm asking you that much longer in the scope of this case. 2 years wouldn't be that much longer because the case is that old, but that's not how long I'm inclined to leave it open.
Sure. Can we get another 6 months?
What I'm going to do is have Ms. Niles check in with you in 3 months. And if there is nothing new about the case, then I will dismiss it for want of prosecution. If there is something you squeezed out some information through the FOIA request or whatnot, then you can keep it on life support. But we'll do a 3-month check-in. And if you can show some substantive progress in sorting out who Shardabin Patel is and whatnot, then we'll keep it open.
Okay, thank you, Your Honor.
All right, thank you.
May I be dismissed?
Yes, sir.
Thank you.
All right, position 2 is Huff Heights versus Smart Room Solutions, which was all set for trial. And on the eve of trial, Huff Heights tried to add or filed a motion to add the actual tenant, not her company, but Ms. Wimberly. And then defense argued, well, that's moot because Ms. Wimberly is moving out. And we got stuck. And here we are. Plaintiff's counsel has not responded to multiple inquiries from my staff attorney about whether they still want to add Ms. Wimberly. And so I'm ready to put this back on a trial calendar. Do we have anyone from Huff Heights on the call?
Yes, Your Honor. Frank Olson here for the HOA.
All right, Mr. Olson. So what is the well, before you go on, do we have Mr. Breedlove?
I'm here, Judge.
Great. Let me get you on the screen as well.
Yep, good seeing you.
There he is. Good seeing you. The familiar pink tie. All right.
You're a celebrity now, Judge. I feel honored to try these cases for you before you were a celebrity.
Yep, we go way back. All right, Mr. Olson. Tell me what is going and not going on with the case.
Okay. First, Your Honor, I apologize for any lack of response by me or my staff to your staff attorney. But here's what's going on. We understand that Ms. Wimberly, the tenant of Smart Room Solutions, actually did move out. I don't know if she did that by the April deadline that they said that she was going to, but I believe she is now gone. My client informs me that there is a new tenant in this property, despite the fact that the HOA has revoked Smart Room Solutions leasing permit that it issued because of the numerous violations that had been committed, including some of the violations that we laid forth in our first amended complaint, which were City of Atlanta ordinance violations.
All right, before you dive deeper, pretty narrow question. Are you still trying to add Ms. Wimberly?
No, but I think we're going to have to add whoever the tenant is because they are leasing.
How quickly can you do that? Because if you thought that Ms. Wimberly was supposed to be gone in April and you don't know that, it doesn't seem like this is a case that the lawyers are pursuing real hard. Here we are in October. So how much time do you need to figure out if you're going to try to add someone and who that person is?
I will say some of this may depend on Mr. Breedlove and his client because they are required under the covenants to disclose who the tenant is and provide a copy of the lease, and they've never done that.
Okay. Well, I don't have a motion before me seeking some sort of injunctive relief, enforcing the covenants or anything like that. I've got this suit that is for damages and foreclosure. As I said, it was trial ready. Huff Heights tried to add someone. Now they're not going to pursue that, and they're now adding a John Doe or Jane Doe, and the case continues to age. So give me your forecast, Mr. Olson, as to where we go next and when we can go wherever that is.
Okay, so I would think that within the next 30 days, I can try to figure out who this person is. I would, if Mr. Breedlove would like to cooperate, that would be great, and just tell me and provide me a copy of the lease. But we're going to have to add that person, and we're going to have to add some claims to the complaint for some kind of, declaratory or equitable relief to declare this an invalid lease and possibly evict that person. So that's.
So the lease is between Smart Room Solutions and Huff Heights. Ms. Wimberly may have been the person behind the corporation. She was in the unit. She's now out of the unit, but you're saying your client tells you someone else is in the unit, and that would be some sublease between Smart Room Solutions and person X.
No, Judge. The plaintiff is the HOA.
Yeah.
Suing to force a tenant out of the property and for multiple fines, which we deemed as frivolous, and the court says so much. Essentially, in your order denying the plaintiff's motion for summary judgment. And so the issue is, first of all, I haven't heard from, respectfully to Mr. Olson, I haven't heard from Mr. Olson since April. When we tried to settle the case after Mr. Wimberly moved out. And so the notion that I'm not cooperating on providing additional information for a new tenant, who we believe our position would be at trial, which I think we should go back to a trial calendar, is that our position is that it should go back to a trial calendar, because we don't believe the revocation of our client's leasing rights is appropriate under these circumstances. We deny the fines. We deny the nature of the fines. As soon as my client was made aware of violations by Ms. Wimberly, which was right before the trial calendar, we were made notice of these violations. Ms. Wimberly moved out, and our client told Ms. Wimberly to move out, and she moved out. They tried to evict her in magistrate court downstairs and were unable to. And so we believe our client, in the spirit of defense posture, Mr. Olson has not pursued this case since earlier this year, has not contacted my office to ask for any information.
Okay, I hear you. It's good to hear both sides. We're not going to solve this right here and right now. I think a healthy forcing mechanism will be for me to put this on a trial calendar. That may prompt Mr. Olson and his team to file some things and do some things. But I'm going to ask you, Mr. Olson, to file within the next 3 business days a withdrawal of your motion to add Ms. Wimberly, because that's what clogged things up for now. You're free to file an additional motion to add mystery person. It sounds like Mr. Breedlove will give you the lease so that you don't have to guess as to the identity of who occupies the unit. And then, as you mentioned, there may be some amendments to your complaint, and that's all fine and good. My concern isn't what's next, it's when is something happening next in this case. So I'll get it on a trial calendar, and if we need to back it off that because of procedural steps the plaintiff takes, great. But at some point we do need to reach closure so that we don't repeat what seems like a cycle now, where someone gets in there, Huff Heights gets unhappy with that, and here we are. So can you file a motion or a withdrawal of your motion to add Ms. Wimberly by the end of this week, Mr. Olson?
Absolutely, Your Honor, I will do.
Oh, great. And then reach out to Mr. Breedlove, see what information you can get from him that will answer some of the questions you understandably have. And then I'll get a trial date for this, and I will back off the trial date if procedurally we need to do it. But I do want to keep a little pressure on so that we move this along. Hold on one second. Did you, you're all right with that? Okay. All right. Mr. Olson, any questions about anything that we just discussed?
No, and that's my only matter before you this afternoon, so if I may be excused.
Can you say that again?
It's my only matter before you. That's my only question, so if I may be excused.
You may. Thanks.
Thank you.
Thank you, Judge. May I be excused?
You both may.
Thank you, Judge.
All right. If anyone was on for position 3, Karen Schern versus David Rowe, that's been resolved, so you can drop off. Position 4 is, I'm not going to pronounce the names well, Ofoche versus Oceanowo and Heist Holdings Incorporated.
Good afternoon, Your Honor. Agbo Ebotabi for Chijioke Ofoche, who is the plaintiff. This is a breach of contract action that we filed sometime in April 2022. We had difficulties serving the defendant. Eventually, the court dismissed the action for lack of service. We refiled and succeeded to serve the corporate defendant through the Secretary of State and served the individual defendant by publication by publication. So we have both affidavits on the docket of the court, and we proceeded to file a motion for default judgment. And here we are. Your Honor, we have on the docket, on the complaint, there is Exhibit A, which is the contract, the initial contract between the parties, and Article 69 of that contract stipulated that Mr. Ofoche is entitled to $20,000 on the $30,000 investment, and that was supposed to be due by the 15th of it was supposed to be due by the 30th of April 2021. So as to the damages, we are asking for the $30,000 initial investment, and we have a copy of that check which is attached to the complaint as Exhibit D. And we are equally asking for the $20,000 return on investment, which was expected to be paid by the 30th of April. That brings up the liquidated damages to $50,000. We equally asking for the plaintiff's attorney fees, which was a flat fee in the amount of $10,000. And we're asking for expenses of the litigation, which we estimate is in the neighborhood of about $1,000. So in all, we're asking for about $61,000 in damages.
All right, hold on 1 second.
Okay.
All right, so I'm looking at the complaint, and
On Exhibit A, which is the
Yeah.
argument, Article 69.
all right, additional clause, 20,000. Okay, got it. And then
Exhibit D, which is check the initial investment, is 30,000.
okay, what I've got for Exhibit B is a priority envelope.
No, D, I'm sorry.
Oh, D Delta. Got it.
Yeah.
Okay. Yep. Okay. And then tell me, you said one thing was you estimate at, and that's not really how we do damages here. When you were listing the components of the damages.
I mentioned the only thing we estimated was the court cost.
Oh, court costs. Okay.
Yes, Your Honor, which is, we find it difficult to really pin down because there are certain items of the cost, like mailings, which we could not have all the receipts of the mailing. Some were by regular mail, some were by priority mail. But as for the filing fees, we filed this action twice. The average filing in Fulton County is $254, if not more, on a contract. So at a minimum, if we look at the cost of service, which we made multiple attempts by private servers, out here in Georgia and out there in California, where we were suspecting that the plaintiff now resides. So we came to a ballpark of about $1,000. And of course, the attorney fees were a flat fee of $10,000.
Tell me, the attorney's fees was this magical round number of $10,000. Is that in the contract, or how did you get to that?
It's a flat fee which charged the plaintiff.
Oh, a flat fee that is charged for this case. And is that documented anywhere?
I have an invoice.
Is that in the record?
No.
It's not part of your affidavit in the motion for default judgment, anything like that?
I do not believe I had it on there. The notice had asked us to submit those by the 9th, but it slipped my mind to be honest.
Okay, well, based on what you've told me, I think an order for default judgment is appropriate. If you would send a proposed order to Ms. Niles and include the amounts broken out, so the 20,000 per paragraph 69, the 30,000 for the check, et cetera. And if you are seeking to recover attorney's fees, also include in what you send to Ms. Niles the evidence that you think would support the notion that there was this flat fee that your client, Mr. Ofoche, agreed to and paid.
Thank you, Your Honor.
All right. Anything else?
No, Your Honor, that concludes my business. May I be excused?
Yes, sir. Thank you.
Have a good day. Be safe.
You too. All right, position 5 is Marjorie Mitchell versus Susanna Mitchell. Another default. Do we have Mr. O'Sullivan? We do. You need to unmute Mr. O'Sullivan.
How about now?
Much better.
Okay. Your Honor, I'm represent the plaintiff. We've resolved this and we're going to be filing a dismissal today.
Fantastic. You've resolved it by interacting with Ms. Mitchell, or does she have counsel?
I am Ms. Mitchell's counsel, and
I wasn't real clear about that because they're all Mitchells. I meant Susanna Mitchell.
Oh, no. Yeah. Yes. Other Ms. Mitchell's counsel and I have resolved this by a settlement agreement. And
Okay.
We are going to be filing a dismissal.
Yeah, and Your Honor, this is David Messer. I am counsel for Susanna Mitchell as the executor of the estate, and I concur that Mr. O'Sullivan and I have reached a settlement agreement in this matter, and we finished that up this morning, and Mr. O'Sullivan's going to be filing a dismissal, so we appreciate the court's work through this process.
Fantastic. Mr. O'Sullivan, we should expect to see that dismissal filed when?
I think today, e-filing, you'll get it today.
Okay, and I know e-file can sometimes be a little slow. We'll just check midweek, and if it's not in there, then Ms. Niles will reach out to you.
Okay.
Okay, Mr. Messer, Mr. O'Sullivan, thank you for your time. You're free to go.
Thank you, Your Honor.
All right, that gets us to another status. Thomas Richelo versus Amy Ransdell and others. Anyone on or here for that? Okay, well, that's an easy one. Inheritance Advanced LLC versus Mr. Heath.
Hi, good afternoon, Your Honor. My name is Tiffany Watkins, and I'm appearing on behalf of plaintiffs Inheritance Advance.
Okay. Do you work with Stacy Evans?
I do indeed, yes.
Great. Okay. So this is a default. Oh yeah, there's your name listed right next to Ms. Evans on this other thing. All right. So Ms. Watkins, tell me what's going on with the case and what amount you think your client is owed.
Yeah, so this is a straightforward breach of contract matter where the defendant, Mr. Heath, irrevocably assigned, sold, and transferred $40,000 of his beneficial interest in the estate of Rosalind Marie Heath to plaintiff in exchange for an immediate cash payment of $20,000. Defendant did receive that immediate cash payment of $20,000. However, defendant has not transferred the $40,000 he assigned to plaintiff pursuant to a written agreement, which is attached to our second amended complaint as Exhibit A. And as such, we filed action against defendant originally on November 7th, 2022. That was amended twice, the latest of which was on December 5th, 2022. And defendant was ultimately formally served with a complaint and summons on February 2nd, 2023. Since that time, defendant has not appeared at all in this action, whether by answer, response of pleading, or any other matter. So that prompted our filing of the motion for entry of default judgment on August 14th of 2023. Included in that motion is an affidavit from myself adhering to the procedural posture of this case, as well as the court costs that we seek in this matter, which amounts to $555.91. That appears as Exhibit A to the motion. Simultaneously filed with the motion was our certificate of default and affidavit of military service in compliance with the Superior Court rules. So overall, we are seeking the $40,000 pursuant to the agreement that's attached to the second amended complaint, in addition to our court costs of $555.91. We do have a prepared proposed order that I'll be happy to send to Ms. Niles at the conclusion of this hearing.
Okay. Tell me what the business proposition is. It basically getting half your money out of the deal, but you get it right away. Is there some uncertainty surrounding whether Mr. Heath would in fact have recovered 40,000, recovered may be the wrong verb, but received as part of the estate, or is it just the immediacy? That seems like a pretty steep discount.
Yeah, so the process is that someone like Mr. Heath would affirm that he will be receiving at least $40,000 out of the administration of the estate that he represents to us. And in exchange for that, he would get the immediate cash payment of $20,000. There are certain segments of time where if you immediately pay it back, it won't amount to the full 40,000. It's kind of like a rebate, it's sooner that you pay it back, you would get a rebate.
Okay. But the facts as admitted by way of the default is that he got Inheritance Advance 20 grand and effectively skipped town. Whether there really was an estate or not, or where he was going to get 40, really doesn't matter. He took the money and effectively ran.
That is correct, Your Honor. And we did have another assignment with Mr. Heath, and that was ultimately paid back. So This is not his first transaction with our company. So
he had a track record of actually fulfilling his end of the bargain, but this time didn't work out. Okay. Well, it seems very organized, and I've looked at the pleadings and things seem to be in order. If you will submit a proposed order in Word format to Ms. Niles, I'll look it over and get it out the door.
Okay. Thank you so much, Your Honor. Hope you have a great rest of your day.
Thank you. You too. Take care.
You too. Bye.
All right, next up is a default judgment matter, Desiree Lusk versus Dennis McKinley. Hey, if you'll come on up to the table in person, this is exciting. So we'll make sure anyone here for Mr. McKinley.
Here myself.
Oh, Mr. McKinley is here. Well, that'll be interesting. Let's get Mr. McKinley on the screen there. And then you're welcome to stand. You also are welcome to sit at council table, whatever you prefer, Ms. Young.
Oh, will I be going first, or will the defendant be going first?
You'll be going first.
Okay, then I'll stand at the podium until my time is finished. Your Honor.
Okay, if you can move the screen a little bit, or if you'll slide over a little bit, that way Mr. McKinley can see you, that'd be great. Okay,
Sure.
so let me tell you what I understand the situation to be. Your client, Ms. Young, Ms. Lusk, entered into a franchise agreement with Mr. McKinley, paid $30,000 to franchise an original hot dog factory franchise. Didn't work out well, and went to arbitration. And an arbitrator, meaning the business arrangements didn't work out well. The arbitration worked out very well for Ms. Lusk. She was awarded $32,000 plus a little bit more about a year ago. And Mr. McKinley hasn't paid that arbitration award. And this is an effort to confirm and enforce that arbitration award.
Correct, Your Honor.
It's got a little twist to it that we can talk about. I'm not sure it's appropriate. I mean, it's appropriate to talk about it, but adding some additional things to the arbitration award, fraud, rescission, things like that. And we can talk about that piece. That to me is less clear. The original action was to confirm and enforce. And if there were concerns about the business relationship between Ms. Lusk and Mr. McKinley, it seems like that should have been brought before the arbitrator as well. But I'm just flagging that as a set of questions I'll have for you, depending on where our discussion goes. But why don't you tell me where you think we are procedurally, and then we can hear from Mr. McKinley.
Your Honor, Mr. McKinley was served with a complaint earlier this year, or last year, actually, Your Honor. And after the complaint, the defendant did not answer. There was communications between myself and his former counsel in regards to attempting to settle the matter. In the process of those talks between myself and former counsel, Your Honor, the time to answer lapsed, and opposing party did not answer, Your Honor. Therefore, because there was never any resolution in regards to the case and there was never an answer filed by the opposing party, Your Honor, we filed a motion for default judgment for the defendant's failure to file an answer in accordance with the laws of the state of Georgia. And so the last time that we were here, Your Honor, the opposing party had made the first payment in regards to the settlement agreement. However, the second payment was due.
When you say settlement agreement, meaning something you and either Mr. McKinley or his prior counsel had agreed to, or what the arbitrator said the agreement is?
No, Your Honor, this is after the arbitration award. Between the time that we filed the motion for the default judgment, Mr. McKinley and myself, on behalf of my client, entered into a settlement agreement. And had those payment terms been complied with by the time of the last time that we were here, Your Honor, then the case was supposed to be dismissed because the redress had been received.
Got it.
However, at the last default judgment hearing that we had, Your Honor, half of that payment had been made from Mr. McKinley to my client. And today, we requested the hearing be rescheduled for today, Your Honor, because the second payment was never made. I did receive communication that payment was going to be made today. However, I have not received communication per the settlement agreement. Mr. McKinley was supposed to inform me that he had made that payment to my client. I have not received that confirmation that that payment has been made. Therefore, Your Honor, we're requesting the default judgment for the remaining amount due, which will be $20,000.
So the first payment was less than half of what the arbitration award was for $32,000, as I said, plus a little bit more. Whatever the settlement agreement was for that amount or for less than that amount?
No, the settlement agreement was for $40,000.
Why would it be more than the arbitration award?
because the arbitration award was one amount, and then it also was inclusive of the attorney's fees that were paid for this case, Your Honor.
Got it.
And in addition, and also in the arbitration agreement, Your Honor, attorney's fees were to be paid. However, they were never paid in the arbitration agreement, which required my client bringing the case before you today.
Okay, and I'm not getting in the middle of the negotiations. There was an agreement reached where Mr. McKinley said, I'll pay X.
Mhm.
He was going to pay it in 2 installments.
Mm.
He paid the first installment, which is why we delayed our default judgment hearing in June of this year. But you're saying he missed the second date.
Correct, Your Honor.
Okay. Mr. McKinley, tell me what you want to tell me, if anything, about this situation.
Judge, good afternoon. Appreciate your time today. I emailed Attorney Lusk and told her I was ready to, I had the funds to pay the second payment. She didn't respond, so I just showed up to court today. I didn't pay it. I'm fully able to take care of, what's owed. I don't have any excuses today, but she didn't respond, so I showed up today.
Okay. So if I heard you correctly, you believe you made outreach to either Ms. Lusk or Ms. Young, didn't hear back, but as you sit here today, you are able and willing to make in full that second payment.
That is correct. I believe the attorney did say she did get an email from me that I was going to pay it, but I didn't hear back, so I showed up today. But that is correct, Your Honor. I am ready to pay the final balance.
Okay. So tell me, Ms. Young, how you want to manage this.
Your Honor, in regards to that, Mr. McKinley has my client's wiring information and the ability to pay her without response from me. And so this was supposed to have been paid almost 2 years ago, and then the other payment was due back in June.
Okay.
Therefore, as of today, the fact that he has not made that payment as of now, I have not received any communication from my client. She is here on Zoom. As to that second payment being made, therefore, Your Honor, I will request that the default judgment be entered. And then once that payment is actually made and confirmed, then I'll go in and file a motion to vacate the judgment.
So I hear your request. I think it's reasonable. I'm going to build in maybe a 48-hour window. If you want to send to Ms. Niles,
Okay.
And copy Mr. McKinley, if you've got his email address, a proposed order for that default judgment, which I'm sure Mr. McKinley doesn't want. No one wants a judgment entered against them.
Correct.
I will not enter it until close of business Wednesday at the earliest. Maybe Thursday morning. But what I'll do is have Ms. Niles check with you first to see if in fact payment's been made. So the onus is on Mr. McKinley to make the payment and to make sure you know he's made the payment. So that would be Ms. Lusk confirming that she received the payment. But if she makes that confirmation, then I don't even need to enter the default judgment. And then I'll just ask you to file a dismissal and the case will go away. But I want to give, because Mr. McKinley showed up, which is an oddity with default judgments, that says to me he is trying to engage. And I'm not going to get in the middle of, hey, I emailed you, you didn't email me back. That's never real productive. But he just told me and you in front of everyone else that he's got the ability to close this one out. So we'll wait until late Wednesday or early Thursday if you get us a proposed order to file it and see if Mr. McKinley can take care of his obligations in that window. Does that work for you and your client?
I believe that works for me and my client, Your Honor. Your Honor, would you like the proposed order to be uploaded through Peach Court or sent directly via email?
Directly via email
All right.
in Word format. Don't like getting proposed orders in the docket because sometimes people think it's an order and it's just a proposed order. So just email it. Please copy Mr. McKinley. And Mr. McKinley, that gives you about 48 hours to do what you're claiming you are ready, willing, and able to do. I would keep a receipt or a proof of payment or whatever it is, just in case wires get crossed and Ms. Young reports back, hey, I don't think Mr. McKinley made that payment, because you can send proof of payment. But I'm hopeful that you send it to Ms. Lusk. She says, I got it, and everyone's business is resolved. Okay? Mr. McKinley, any questions about that?
No, Your Honor. Thank you for your time.
You bet. Thanks for being here.
Thank you, Your Honor. That's all that I have before you today. May I be excused?
Yep. So we'll look for that proposed order. We'll hold tight to it till, like I said, late Wednesday, early Thursday, and then we'll just confirm with you whether it should be entered or not. Okay.
Thank you, Your Honor.
All right. Thanks, everyone.
Thank you.
All right, next up is CNA Direct Assignment versus Jose Luis Mendoza Gutierrez.
Henry Potter, the plaintiff, Your Honor.
Hey, Mr. Potter, how are you?
I am all right. I seem to be one of the few lawyers here who didn't know this was a Zoom hearing. But other
Well,
than that, I'm
It's
just-
always nice to see people. Let's just make sure we don't have Mr. Mendoza. I don't see him on there. Are you Mr. Mendoza?
Yes.
Hey, Mr. Mendoza, why don't you come over here? You can sit at the table right there, please.
Before we start, sir, we're gonna get interpreter. I don't speak English, 100%, just 50%.
Okay, we'll see if we can line up an interpreter. And Mr. Potter, if you don't mind sitting tight, if we can get an interpreter in short order, we'll do that. If we can't, we'll need to reset this, okay? Can you reach out to, do you know the interpreter contact?
No.
If you reach out to Robin Cogswell or Tanja, they'll connect. I don't remember the guy's name. Michael something is the interpreter coordinator, but it's Carlos Lares is who will probably zip over here.
Okay, if there's a room I can go to see someone in person, since emails aren't answered and phone calls aren't picked up lately anymore.
We'll figure it out.
Okay,
All right.
I'll go fetch him if necessary.
Oh, no, he'll,
Okay. Thank you.
if he's not here, it's because he's doing something in another courtroom.
Okay.
So we'll hold on to that one.
Thank you.
Robin and Tanja Richardson, is that the? Yeah, Tanja Richardson. If you send something to the two of them, it's someone who works for Tanja who sits atop the interpreters. I just don't remember his name.
Okay.
Just say, hey, we have an emergency need for an interpreter in 8D, and one of them will push it to the right person. All right, we will leapfrog to position 10, which is another default. Oh, this case. So this is real estate acquisition and development versus Charles Simmerly and Mustafa Tashtanov.
Your Honor.
You are Mr. Simmerly.
I'm Mr. Simmerly.
Great. Why don't you take a seat right there?
Okay.
Who do we have for real estate acquisition?
Your Honor, this is Andrew Becker on behalf of Real Estate Acquisition. I also have a client representative here today, Alex Sinman. And my understanding is Mr. Tashtanov's attorney, Mr. Deaver, is also watching. And my office had arranged for a court reporter who I believe is also here.
That's me. Good afternoon.
Good afternoon, Your Honor. Hey, Steve. I'm here observing for defendant Mustafa Tashtanov.
All right, well, let's get on the record then. This is 2023 CV 375000. We have Ms. Hobson taking things down. The case is real estate acquisition and development versus Charles Simmerly and Mustafa Tashtanov. Mr. Simmerly is here in court representing himself. Mr. Tashtanov is represented by Mr. Deaver. And we have on behalf of real estate acquisition, Mr. Becker. Mr. Becker, why don't you lay the framework of what's going on, what the posture of the case is?
All right, Your Honor. Thank you. There is a few things going on. So number one, this case has two defendants, Charles Simmerly and Mustafa Tashtanov. Mr. Simmerly was served. He did not answer. This is the first time he has appeared in this matter.
Well, now I've met him before, so that's not accurate. I don't know why Mr. Simmerly was in court before. I can look into the docket. But there was something about this case and Mr. Simmerly appeared. So he has been in my courtroom before on this case.
Amen to
I
that.
was not aware of that, Your Honor. We have.
Hold on one second.
It was a very default hearing. They asked for continuance. It was continued, but he.
Got it. Okay. This was calendared for a default hearing earlier this year. Mr. Becker, your side asked for a continuance and it was granted. But word of that continuance didn't get to Mr. Simmerly. So this would have been August 4th of this year. And I had other things on the calendar and there's this guy sitting here. What are you doing here? And the answer was he was showing up for this case. So doesn't mean he's filed anything, but he just wanted to correct the record since it's being taken down. Mr. Simmerly showed up for the last setting of this default hearing.
Understood, Your Honor. I was not aware of that. Mr. Simmerly had not filed an answer. And so earlier this year, we had filed a motion for default because the damages were unliquidated. It needed to be set down for a hearing. And this matter really has two different numbers, two different damage amounts that we need to talk about because there were two different projects. One of those projects has a fairly basic damage amount, and then the other is a little more complex, and that might be why the court saw there were a lot of documents we provided in anticipation of this hearing, so the court would have them to understand the damage amounts. To take the court through initially, the first project we call the Montreal project, and this appears in count 2 of the lawsuit. And this is we're seeking the amount of $50,000 for materials that my client paid for that were not delivered to the project. And that's really the extent of it. My client paid $70,000 initially under the contract. He was told 20 was for labor and fuel, 50 was for materials. No materials were ever delivered. And we are asking for the value of materials that were paid for but never delivered to the project.
So that's as against both all of the counts against both defendants?
Yes, Your Honor, because our argument is that this was a partnership that we had contract. We actually reached out to defendant Tashtanov for this work. And it's our allegation that defendant Tashtanov then said, I'm going to have my business partner come out and give you an estimate. And that sort of led to this situation. However, defendant Tashtanov has filed an answer and we have been engaged in discovery. So as far as this hearing itself, it's only against defendant Simmerly.
Okay. And what do I need to do to guard against double recovery?
We allege if they're a partnership, Your Honor, they're jointly and severally liable. So
okay.
It's not a question of, if the question really comes down to, we have an argument that we're entitled to certain damages. Mr. Tashtanov's answer indicates he does not believe he was ever part of this contract or ever part of this business arrangement at all. And so that's probably going to be one of the primary issues for this court is the liability of Mr. Tashtanov and damages, while right now it's just damages for Mr. Simmerly.
Okay.
So we have, we call it the Montreal project, we have a total of $50,000 that we're seeking, that is for materials that we paid for that were not provided. And those are the exhibits that go with that are exhibits 1, 2, and 3 that were emailed last Monday. Exhibit 1 was the proposal. Exhibit 2 was a copy of a contract, and Exhibit 3 was a copy of the $70,000 check that my client paid. The second contract we have project we call the Nesbitt project. And Nesbitt is a little more complex because Nesbitt was a $150,000 project. My client paid $85,000. The work was not completed. My client self-performed all of the work. And those are all of the exhibits that the court has. The court has a copy of the initial proposal, which is Exhibit 4. Exhibit 5 are the checks totaling $85,000. And then we have a demonstrative aid, which is sort of just a calculation as to how much in total was spent. And then we have exhibits 7 through 12, which are all of the invoices, everything we have as to the actual amount of money my client spent to finish the project. And in total, after deducting the contract balance, we are seeking a grand total of $961,311.12. That is the exact math that we have here. The documents show all of the costs. Now, one of the things the documents show is that my client actually purchased the heavy equipment needed for this project. My client purchased the heavy equipment because it actually was cheaper than renting it. The cost for renting it would have reached almost $1 million. Instead, my client is all they're seeking is the depreciation on that equipment for the period they were using it for this project, which is $300 and something thousand, as shown on that exhibit. I believe it is.
I'm not finding numbered exhibits. I'm flipping through and there are 1 billion receipts. I see where your client bought a crawler dump truck and a dozer and whatnot, but where they're not numbered. It's just all these pages in
Understood, Your Honor. We had numbered them after the fact, and as we can go through, and I'm happy to send you them in numbered format. We had sent everything we were going to use. I can put them on the screen, and the court can see exactly what we're talking about.
Okay.
And Your Honor, if you like, I can go through with my client all of these exhibits, and that way you can see exactly what we're talking about.
All right. So we hadn't set this up. For how long do you think your presentation will go? Because we may need to reset this to give you an adequate window to present everything you need to present. The damages for the Nesbitt Ferry property, that's a big number, and I'm going to need to be persuaded that buying a dump truck is cheaper than renting a dump truck, and understand the depreciation calculations, et cetera. So this is pretty aggressive positioning of your damages as to the Nesbitt Ferry. I want to make sure you've got a full opportunity to flesh it out. How much time were you envisioning it would take?
Your Honor, I do suspect that if we're on, this is not a 5 to 10 minute presentation. And so, and especially if Mr. Simmerly is going to appear, I suspect it probably is better if we do it in the courtroom.
I think that's right. And then having the exhibits numbered rather than bouncing around. Because as I said, I see all the documents. They're not probably in the order in which you're going to be presenting them. So, but Before we decide that though, why don't we hear briefly from Mr. Simmerly? He's been shaking his head a lot as you've been talking about things, Mr. Becker, and I'm going to orient him a little bit, and then I want to give him a chance to share his perspective. So, Mr. Simmerly, I know you're not a lawyer. You and I talked about that informally when you showed up in August of this year. Where your case is right now is because you didn't file an answer. You have effectively admitted to being liable for the lack of performance. Those are going to be my words, not yours. So I'm making this up. If real estate acquisition contracted with you and Mr. Tashtanov to put in a driveway, the allegation is you guys never put in the driveway. And they sent you 50 grand to build the driveway and you never did it. You have, because you didn't file an answer, admitted, yep, we took the money and we didn't build the driveway. So what you're limited to arguing, not today probably, but when we reconvene, should you want to, is those numbers aren't quite right. Not that I didn't do it, but those numbers aren't right. So it wasn't $50,000, or a dump truck wouldn't cost $100,000, or renting a dump truck would be $100 a day. So unless you're going to have that dump truck for 4 years in a row, it would be cheaper to rent it. So you'd be able to argue some about dollar amounts, but what you wouldn't be able to argue, and I'd have to cut you off each time, like, wait a minute, but I didn't do that. That's Tashtanov. He's got a lawyer. His lawyer is arguing certain things.
What Mustafa and him had in their deal and whatever, I have no idea what they were saying. They said it in Russian at the time. Needless to say, I don't speak Russian. I'm an American. But the first job where I started, right here, this is the proposal for the job. They have a signed contract that they agreed to that they defaulted. Okay. He gave me $70,000. I'm out here busting my hump, got men working. Okay. The county comes out and tells me that there's no paperwork for me to be working on this job, period. None. Hasn't been in over a year. And the man signed a contract with me, lied to me to my face, saying that he had every one, the ground disturbance permits, the building permits, and the sewer permits. He had none of those. Okay, so he defaulted to start with on that one.
So did you return most of the money then?
No, sir. I busted my hump for 2 months. I took down trees. I worked and got it ready, got his wall built for his pond in the bottom, everything. I done more than $70,000 worth of work on that job.
Okay.
Okay. The second job, but praise the Lord, I was handed a geo report that says trash was 9 feet deep. This is what I done my proposal off of. Okay. Where it said it was 9 feet, it was 17 feet deep. There was never, not one time, a trash dumpster there for me to put trash in to get it off the site. What I had to do, dig a hole over here, put the trash back in that hole, move over here till he gets up, put the trash back in that hole, put all the dirt that his geo person says that dirt cannot be used on this job. That's the only dirt I agreed to. And right here is the report right in front of me. I can hand you a copy of it or hand you this copy. All it says is I would get trash out of it, put it in a dumpster, put the dirt back that I took out, and that was it. That was the whole job. Now they're trying to say that I'm responsible for all the trash they had to throw out there, that they did not in any form or fashion bring me a tractor and trailer, a dump truck. They didn't even bring me a waste basket to put this trash in.
So in the end,
and then he comes, let me finish. Then he comes out and tells me I have to do this whole job over again for free because he didn't bring out dumpsters. You know what I told him? Have a nice life. Yes, sir. I've done more than $150,000 worth of work.
Stop
May I have
for
the witness? So I'm sorry, Your Honor. I'm trying to report this. Could I have the witness? I'm sorry, the witness. May I have him in the courtroom? Could he move over so I can see him? He's not in the frame. I like to see the person I'm trying to report.
Okay, he's almost done. But I'll see if I can make that happen.
That's the first
Thank you so much. That really okay. Thank you. Sorry for the interruption.
That's Montreal Court.
Okay. You don't have to hold the paper up.
Oh, okay.
She's not writing that down. She just, she prefer to see you. Now we can see you.
Okay, I'll give them whatever they need to see.
Okay.
They have a copy of these.
All right. So it sounds like we need to set this down one more time. Mr. Simmerly, you knew to be here today because you got an email or you got something in the
I
mail?
was emailed by Ms. Niles.
Excellent. Well, we'll do that again. What I'm going to do, Mr. Becker, is have Ms. Niles reach out to you. You can let her know how much time you think you would need to make your presentation, so that we block out enough time for it. And then we'll let you and Mr. Simmerly as well as Mr. Deaver know when we are reconvening for a more complete evidentiary hearing. And I apologize. I didn't know that it was going to be as involved as this is. And I want to give everyone who needs to be heard an opportunity to be heard. But we were not going to be able to shoehorn that in with all the others, given the window that we've set for this calendar.
Your Honor, we have, if I may.
Go ahead.
We have sent Mr. Simmerly a notice for his deposition. And it might be worthwhile if we can conduct his deposition before we do the default hearing. That might make it a little more cleaner.
Okay.
We had sent in a motion to extend discovery, which the court had, I think, ruled to close on October 30th. If I may make an oral motion so that we have a little more time to get our discovery done, especially in light of today and just the scheduling, at least between my client and Mr. Tashtanoff. If we could extend the discovery through the end of November, I think that might also make everything a little cleaner.
Is there more discovery you need to do other than a deposition of Mr. Simmerly?
The parties have not been able to get all of our party depositions scheduled. Part of it was we had produced the same documents that your office had received on last Monday. I think that was when we were able to get a lot of those documents to Mr. Tashtanoff's attorney. And originally we were going to do a deposition, some of the depositions last week, but we wanted to be fair to Mr. Tashtanoff and his attorney and give them time to review the additional documentation.
Okay.
And so really we have a couple of depositions to do, and depending upon what Mr. Simmerly says or what Mr. Tashtanoff says, that could lead to one or two more. And that's really, the parties have done their written discovery, but it's the depositions that we need to do. And what makes it a little more complex, Your Honor, is that for both of the remaining parties in discovery, both of them require different interpreters. My client we're using a Russian interpreter, and Mr. Tashtanoff is using a Turkish interpreter.
Okay. You mentioned that you were seeking Mr. Simmerly's deposition. Did you notice it and he didn't show up, or you just hadn't agreed on a date yet?
We've noticed it. We haven't heard from Mr. Simmerly. We hadn't heard. We didn't know whether he was showing up. I thought I would use this opportunity where he is in front of us to ask him if he had actually received our deposition notice.
No, sent me nothing.
Yeah, he hasn't received anything. So it may be that you don't have a great way to contact him, but we'll sort that out so that you do have a good way to contact him. He can let us know if it's going to be email, post office, what he can choose the channel. But Mr. Simmerly, what Mr. Becker is asking to do, I think makes a lot of sense. So you have a chance to educate the lawyers on the other side about a lot of what you were sharing with me. And all a deposition is when you may know, I'm not talking down to you. You like to tell me you're not the lawyer, but a deposition is when lawyers sit down with a witness and ask the kind of questions they would if there's going to be a trial. There's not going to be a trial in your case, but they would be able to get information from you about your perspective on this, like you already started to share. And they're entitled to do it. It's actually not something you can say, no, thank you. You need to show up, but it needs to fit with your schedule. You're a busy person running your own business. and we'll need to make sure that it comports with your schedule. What's the best way for Mr. Becker to contact you? Is it phone or email? What would you prefer?
It doesn't matter. He can send me a letter. He can come to my house. It doesn't matter to me.
Okay.
I have done nothing wrong.
Well, and this isn't about people doing stuff wrong. I just want to know.
Whatever he wants, that's fine with me.
Okay.
Your
But
Honor,
what's
we
the,
have
if
been
he's,
sending correspondence to the, I believe it's the 982 Martins Ford Road in Dahlonega.
Yes, sir.
That
That's
is
me.
where, and I'm just double checking my records right now. I believe we sent the deposition notice to, and I'm just bringing up everything. Because again, I want to make certain that if we schedule and you know, if he doesn't get it, if he doesn't appear, you know, we have everything set up.
no, so that you can compel his attendance if he doesn't. So the address that's in the complaint for you, it's public, so I'm not giving anything away.
That's my address, my email, everything's in there.
I just have 982 Martins Ford Road in Dahlonega, 30533.
Yep, that's my address.
Okay. Do you have an email address or a phone?
Yes, he has it.
Okay.
I
So
do not know if I have the email address.
Alex Tisman has everything I have. He
okay.
has my email, he has my business license, he has my insurance that I had to carry for him, everything.
What I'll do, Mr. Becker, is have Ms. Niles send an email to you and Mr. Simmerly so that you have each other's email addresses. We know that the mailing address you've been using is the correct one.
Mhm.
And I'll let you coordinate with Mr. Simmerly about a date and time for a deposition.
I'll go to his office now.
Okay. Probably now isn't going to work, but going to his office is what you're going to end up doing. And we just need to sort out a time that works for both sides. So I'm going to leave that to you all. I am open to extending discovery, in particular for the conversation with Mr. Simmerly, but you've helped me understand, Mr. Becker, that Mr. Tashinov may need a little time through his lawyers to process the discovery you provided, and then you still need to have depositions go in both directions there. So why don't you send a proposed revised scheduling order that would include a deadline for discovery, and we'll set a new default hearing that would be after discovery closes, because by that date, you should have taken the depositions you need. It's your job, Mr. Becker, to let Ms. Niles know if you're having trouble scheduling Mr. Simmerly's deposition. I'm going to assume, if I don't hear from you, that you've been able to do that, so that if discovery closes and we haven't heard from you, if you didn't take the deposition, that's on you. If you tried to take it but couldn't and let us know, that's on me, and I'll make it happen so that when we do convene for the default hearing, it's just that case. We don't have it on a calendar with 15 other cases, and we'll have enough time to work through everyone's perspective.
Excellent. Thank you, Your Honor.
Mr. Deaver, is there anything you want to add?
No, Your Honor, not at this time. I mean, obviously, my client has his own position on this matter, and that being that there was no partnership, that his role in these projects was limited to providing equipment that was leased by Mr. Simmerly. But that's for another day. Appreciate your attention to this, and just we'll let you know if anything comes up.
Okay. All right, Mr. Simmerly, anything else from you?
No, sir, but next time we come to court, am I gonna be able to look the man who's accusing me in the face?
So
Or am I gonna be on a computer attorney again?
I'm going to have the lawyers be here. Whether their clients are here or not is up to
The lawyer
them.
doesn't be able to look me in the face and lie to me.
Okay. Well,
Okay, I want to see my accusers in front of me. I have that right, and I would like to see it.
so the good news for you is not a criminal case. So you don't have that
They're close to
confrontation.
criminal. They're trying to steal $1 million from me. Yes, sir. It's criminal.
Okay. I hear you. I know you'll be here, and it will be an in-person hearing. So anyone who's going to testify on behalf of plaintiff, or if Mr. Tashinov's getting in the mix on behalf of him, will need to be here in person as well. Okay.
Yes, sir.
All right. So Mr. Becker, we'll look for that proposed scheduling order and take it from there.
Yes, Your Honor. And I believe that is all the business I have before the court today. May I be excused?
As long as you take care of business arrangements with Ms. Hobson.
Yes, that was through my office that we had done it. But if Ms. Hobson needs anything from me right now, I'm happy to provide it.
I'm good. Thank you very much, everyone.
Excellent.
All right, then, Mr. Simmerly, good to see you again. You're free to go. Mr. Deaver and Mr. Becker, we'll see you again soon.
Excellent. Thank you, Your Honor.
Thank you, Your Honor.
All right, we are going to go back to CNA direct assignment. We have a translator here. So Mr. Mendoza, you can sit at either table.
Buenas tardes.
Buenas tardes.
Un segundo, yo lo voy a estar susurrando de acá. Para que tenga. Entonces me va a preguntar a mí primero.
Cheers.
All right, we're not on the record here, so Mr. Mendoza Gutierrez, your interpreter, your translator is going to just help you work through what we're talking about.
Lo que estamos hablando.
All right, Mr. Potter, when you're ready.
Cuando usted esté listo.
Tell me if I talk too fast.
Okay.
Your Honor,
Su señoría.
this case is a workers' compensation case where a retrospective audit is allowed under Georgia law because the amount of the premiums to be determined is not known until the end of the policy period. I've had enough of these before you. I think you're familiar with them.
Hold on one second.
Sure.
Can you speak closer to the microphone, please?
Of course.
Thank you.
Okay, so this is a workers' comp and employers liability case where there was an audit performed. There were 3 separate policies. An actual physical audit was performed on each of the policies. This is an assigned risk case. My client had no choice but to take the case when it was assigned to them by the NCCI. For the first.
What does that mean?
NCCI?
No, like an assigned risk and your client had to take it. What does that mean?
Okay. Everyone who employs someone has to have workers' compensation insurance under Georgia law. Insurance companies don't want to insure everyone that wants a policy of workers' compensation insurance. Once you have applied for 3 different policies of workers' compensation insurance on what's called the voluntary market, you are then switched to the assigned risk market.
Meaning if you can't secure coverage, you're 0 for 3.
Right.
Then you go to the assigned risk and CNA direct assignment got this policy.
Right. And you'll see in the, though their agent did not fill out the 3 names of the people that he was unable to get policies with, it was sworn by the defendant's agent that it was. I don't have the citation for it at the moment, but the Dennis Perry Holmes case sets forth the concept that the agent in an assigned risk case is always the agent for the insured. So if you wish to write policies on the voluntary market, you are assigned through the National Council on Compensation Insurance, the NCCI, a policy of insurance, and you have to take it. I'm talking too fast.
Can you slow down?
Yes.
Because this is a language.
Yes.
Yeah, it's complicated terms. I wish this were just like a car accident. It would be easier to
So I
follow.
will back up a little bit.
See, when you talk about, all the CNN and all the policy, because it's that the language is
talk
kind of
slow.
difficult, so slower would be nice.
Okay.
How about I ask some questions?
Okay.
Mr. Mendoza, is he an employer or an employee?
He's an employer.
His company wasn't paying premiums.
Well, his company took out a workers' compensation policy, paid the minimum premium of $1,559, which is actually $1,600. I don't know what's, and then it has to be, the policy then has to be issued once it's assigned.
Okay, so he paid a premium.
Paid a small premium,
Okay,
and then that goes into the pool of the NCCI, and they assign the risk to my client, CNA, direct assignment.
okay,
And then the policy was in effect for 3 years. An audit of the defendant's records was made after the first year, the second year, and the third year.
and he hadn't been paying in, or is he takes out of payroll? If I get paid $10,000 by him, out of my paycheck, money should go into this, or it comes directly
No.
from the employer?
Okay, the manner in which workers' compensation premiums are calculated is that for every $100 of compensation paid to an employee or an uninsured contractor, and there's a rate. For example, on roofing for workers' comp, it's $130 for every $100 that you pay a worker.
Dangerous profession.
For me, I'm class code 8858 and 8868, and I might get a staple or poke myself with a pencil, and mine is like $1 per 100 or less.
So the allegation that's been admitted through default is that Mr. Mendoza, I'm just trying to figure out why it's personal liability here. But before we get there, it's that he wasn't paying what the premia were over time.
Well, actually, the premium comes due at the end of each policy period. We've attached all those amounts to the complaint showing the policies that were issued and his failure to pay the premium, which when billed.
So they look at the payroll and then they use the percentage and have determined that there was a shortfall in premium paid each year based on the total payroll.
Right. Essentially what he did was he went in and he paid the minimum each year.
Meaning the 1,600.
Yeah, 16 and then 15 and then 15. And it's all set out in the complaint.
So I'm looking at.
And all set out in the affidavit of Laura Leyland, which was filed on the 12th. And I have a copy here in case it is not up on your docket yet.
What is, why is Mr. Mendoza liable as opposed to Mendoza Construction or whatever the company was?
The reason why Mr. Mendoza is the one that is on the hook is that when he filled out the application, he applied under the name Jose Luis Mendoza Gutierrez.
Okay.
And so therefore, when he applied for the policy under his own name, and he did have his own federal tax ID number, so that I assume is just the manner in which he operates.
Where would I
as a sole
find,
proprietor?
where would I find the application?
The application is attached to the complaint as Exhibit A. The first page of the application shows the name of the applicant.
Okay, let me look at it. I see it.
And you'll see he signed it in his individual capacity on page 4 of that application, which it goes 1, 3, 2, 4 because of the way it's sent to us and the way it was copied. Or did they do double sided? No, they did both sides. No, because we have both sides. That's what it is.
Okay, and so it's got the rates, it's masonry work.
Correct.
And that's class code 5022.
Right.
So that's a rate of 50.38. So for every $100 paid in wages, $50.38 needs to be paid into workers' comp.
That is correct, Your Honor. You'll notice when he filled out the application, he estimated his entire payroll for a 12-month period to be 0.
Y en 12 meses.
so as to get the lowest rate possible.
Para poder pagar.
Or he didn't know how to fill out the form. But either way, it's how the form was filled out.
His agent filled out the form for him.
Oh,
So the agent is my right agency.
okay. And if you estimate zero, you get that low rate, but then you have to top it off as you start paying more than zero wages.
Tiene que pagar más.
Yes, at the end, once an audited figure is arrived at.
Okay. And then this lawsuit is filed because there is this significant arrearage in premiums. And Mr. Mendoza Gutierrez did not answer.
No contestó.
Correct.
Okay. I'm much more oriented now. So what's the non-liquidated part of this?
There's no non-liquidated part. We filed an affidavit and a 902 notice, and we rely on the contents of that affidavit, that being Laura Leyland, who is a director for plaintiff, though she left that blank.
Okay. And I see you've got a proposed order here that has the principal sum and then prejudgment interest.
Yes, prejudgment interest was calculated under OCGA 742, setting the interest rate for contracts where no interest rate is set at 7% under Georgia law.
Okay. So the only thing that's changed is interest. It's now about double because time has passed. When I look at your complaint, you are seeking the,
And when we have I'm sorry, Your Honor, I did not mean to interrupt.
That's all right.
Our accounting software adds the interest on, and we drafted a new order when we filed this and forwarded it to you in August. And that interest rate should be acceptable because.
Oh, I don't have an issue. I'm looking at the math. It seems like it's on. It just, what was prayed for in the complaint, the principal has not changed. Good sign, but the interest has, and that makes sense. Okay. Mr. Mendoza Gutierrez, do you have any questions? You don't have to stand. No, it's okay.
¿Tiene alguna pregunta?
¿De dónde obtuvieron las cifras que me están cobrando?
Where did they get the amount of money they're charging me right now?
So, what's the name of your company?
El nombre de su compañía.
No tenía compañía.
I didn't have a company.
Did you do masonry work?
Yo trabajo de albañilería.
Sí.
Yes.
Did people work with you or did you do all the work by yourself?
Empecé a trabajar solo.
I started working alone.
But then?
Y después tuve que contratar gente.
And then I had to hire people.
Okay. At some point, you got workers' compensation insurance.
No he trabajado en seguro, ¿cierto?
Por medio de una agencia fui a contratarle la primera vez.
Through an agency, I went to get it the first time.
Yes.
Sí.
And the way workers' compensation insurance works is that the more you pay your workers,
A sus empleados.
the more you have to pay into the system. And you may not have known that,
Usted no haya sabido eso.
but that doesn't mean you don't have that obligation.
Habilidad de pagar eso.
La compañía donde yo fui,
The company that I went,
Right Agency,
Right Agency,
ellos me ofrecieron una workers' comp.
they offered me the workers' comp.
Ellos me dijeron que esa póliza cubría una persona.
They told me that would cover one person.
Ok, ellos se encargaban incluso de mis auditorías.
And they were in charge of my audits.
Cada año ellos manejaban todo lo que era lo que era workers' comp.
They did everything they had to do with workers' comp.
Llegaban las auditorías y yo les hablaba a ellos.
The audits would come and I would call them.
Y ellos me ofrecían el servicio de contador arreglándome la auditoría.
And they will offer me the accounting service and helping me with the audits.
Y todo estaba bien al parecer.
It seems to me that everything was fine.
Yo no sabía exactamente qué era lo que estaba pasando porque yo pagaba $500.
I didn't know what was going on because I was paying $500, $500
para la auditoría.
For the audit.
Y tengo los cheques.
I had the checks.
When the audit was done,
Debía decir that.
did the agency tell you you need to pay more premiums?
No.
So you may have a claim against the agency,
Contra de esa agencia.
Because it sounds like maybe they were giving you bad
Dándole
information.
equivocada.
But what happened
Lo que sucedió
was that you were paying your workers,
pagan a sus empleados.
and that audit should have said that you also need to pay a little more into workers' compensation,
Compensación al trabajador.
but you didn't.
Pero usted no lo hizo.
Maybe because no one told you you needed to.
Sí, tenía que hacerlo.
No sabía, era mi primera vez.
I
Estaba
didn't
como
know it was my
como
first time.
Sure.
As a subcontractor.
Understood? And that
Y por eso,
is an explanation, but it doesn't excuse non-payment.
a usted no pagar lo que debe.
Does that make sense?
Entiende.
Sí, entiendo.
I do understand.
Okay, so the lawsuit was simply to get you to pay the premiums that the right agency should have told you you needed to pay.
Haber dicho correctamente lo que no se había pagado.
Sí, yo no lo sabía, dice que
I
es
didn't know.
$50 de cada $100, o sea, no es ni siquiera lo que gané en el año.
$50 for every $100, not even what I made a year.
Insurance, that's why workers' comp is out of reach for some.
Para algunas personas no es feasible.
You heard what Mr. Potter said. For roofers,
Para los que trabajan en techos,
the employer actually has to pay more than wages.
de lo que gana la gente.
For every $100 you pay a roofer,
Paga un
you'd have to pay 150 into workers' comp,
compensación al trabajo.
which means you would charge me as the customer a whole lot of money for the roof.
Lo ponen a mí como cliente porque por eso se paga más por los techos.
And it means you're going to need to charge your customers more going forward.
De aquí en adelante para cubrir compensación.
Bueno, lo que pasa que desde que a mí me cancelaron la póliza, yo no he tenido trabajo como subcontratista, trabajo por horas. Yo
But
no
since
tengo
they canceled my
ese
insurance,
dinero.
I haven't had that job as a subcontractor. I don't have that money.
Got it. Okay. All right.
Have it.
Well, what will happen, Mr. Mendoza, is that there will be a judgment entered,
La decisión del juez.
and you cannot pay what you don't have.
No puede pagar lo que no tiene.
We don't have a debtor's prison or anything like that.
Una prisión para la gente que no puede pagar.
But
Pero
as you earn more money doing something different,
tiene que hacer algo diferente.
or if you win the lottery,
Diferente o se gana la lotería.
some of those earnings
Hay ganancias
would go to pay down this judgment.
a este fallo que yo voy a dar, que usted tiene que pagar.
Okay.
Está bien, solo quiero que tome en cuenta que soy padre de familia, tengo 3 hijas, una en la universidad, trabajo, gano $30 por hora.
Well, you have to take into account that I'm a father. I have 3 daughters, one in the university. I make $30 an hour. Continue.
Y mi esposa trabaja medio tiempo.
My wife work half time.
So, lo que quiero decir es de que no tengo como para pagar tanto dinero, como $1,000, $2,000 mensuales, no.
I don't have,
No
what
sé
I'm
cómo lo
trying to
pueda
say is like, I don't have the money to pay $1,000 to $1,000 a month. I don't know how I'm going to pay these.
Right. And so that means you'll pay it in very small pieces.
things.
No one's going to take food off the table or pull your daughter out of university.
O sacar, que usted saque su hija de la universidad.
But it may mean instead of getting a fancy wristwatch,
Compra un regalo caro,
you're paying this down
va a
some.
tener que ir pagando hacia esa deuda.
Okay.
Sí, yo no me niego a lo que debo.
I'm not going to
Simplemente
deny
fui
what I
una
owe.
víctima de una agencia que por tal de vender no te dicen las cosas como son.
So I'm just a victim of an agency. They're just trying to sell and they don't give me the correct information.
That may be. Mr. Potter, did you have anything you wanted to add?
What I would like for
Lo que
you
yo
to
quisiera
do
hacer con usted
is meet with an
era
interpreter,
con un intérprete
put together
y poner un
documentation showing your
documento
present
todo esto,
financial condition.
sus condiciones económicas
And
actuales
under the
y
rules of the
bajo las
NCCI,
reglas
they have to
de
take that
esto tienen
into
que tomar
account
eso en consideración
in determining
y
any settlement.
determinar un arreglo. O puede
So
ser
we
una
may be able to
negociación.
work from here
Tal vez podemos trabajar de aquí en
on that.
adelante
Just
con
make
eso.
sure you get me
Ah,
the financial
Deme la
information,
información
like
económica
tax
suya,
returns,
la
so.
declaración de impuestos y todo eso.
Okay.
Está bien para hacer un
Está bien.
arreglo.
Sí,
Yes,
perfecto.
perfect.
Excellent. Thank you, ma'am, for your assistance.
You're welcome.
Mr. Mendoza, I wish you the best, okay? No one thinks you were cheating anyone. You had bad information.
Que usted le estaba haciendo trampa a nadie, simplemente tuvo la información incorrecta.
Okay.
Yes.
Gracias.
Mr. Potter, thank you for your advice to Mr. Mendoza.
Thank you, Your Honor.
I've got the proposed order. We'll take care of it from here.
That's all I have today. May I be excused?
You may.
Turkish interpreter. One day I'll tell you about the fun I had getting an Albanian interpreter.
All right.
Have a good day, Your Honor.
Bye.
Mr. Mendoza. I look forward to hearing from you. This is my business card. You should already have my email address. Thank you.
Gracias, señoría.
Thank you, Your Honor.
You're welcome. Hello.
How you doing?
I'm fine. Let me sign that so you can. That's all right. Yeah, where do you want me to write it down?
No, just here, and I'm gonna wrap the information here.
Okay. It is number, I sort of wrote through it, but number 9.
Okay. Oh, I'm glad you did it in regular language. I wasn't understanding anything at the beginning.
Yeah. I figured if I started asking questions, that would
That was
help.
perfect, because I was like, there's regulation, CNA, etc.
Yeah.
I was like, I don't know what is he talking about.
Mr. Richelo, are you on?
Yes, I am, Your Honor. Good afternoon.
Good afternoon. We're going to go back to your case. And thank you. Appreciate it. There he is. Good afternoon. You are position 6. And we're trying to figure out what's going on. I entered an order on your motion to compel 9 months ago. And we need to figure out what's next.
Well, Your Honor, that was a motion to compel responses to post-judgment discovery. All of the preconditions to that were made, and the defendants were obligated to provide the discovery 14 days after they get served. I have not been able to serve them. From all appearances, I know the place of business of the defendants has been vacated by them. That happened almost a year ago. The individual defendant does not seem to be residing at the address that I had for her. And frankly, in the course of looking into things, I discovered that there were some other judgments with priority over this judgment. So candidly, I haven't made any efforts for a while with the intention that if it doesn't affect anything the court's doing, it'd be one of these things that I would, check on perhaps twice a year to see whether some good fortune had befallen me, otherwise to just let it sit dormant.
So I think we can do that. What I'll do is move it to an inactive status. And I think what we'll do is give it maybe about a year. And if nothing has changed, then we'll probably dismiss it for want of prosecution. I don't know what would change if nothing happens over the next 12 months, why we would think that month 13, 14, or 15 would be any more fortuitous for you.
That seems reasonable, Your Honor. I have no problem with that.
Okay. Then I will sign an order that moves this to inactive status and gives it that 1 year. It's not really a fuse. That's a very long fuse clock. And at the end of that 1 year, as I said, if nothing has advanced, then we'll dismiss the case.
All right. I would assume then I would receive a notice that the court's contemplating doing that sometime next year.
No, what you'll get is a copy of the order that puts it on the inactive docket. And then in that language, in the order's language, it will say if this case has not advanced in any way by, we'll call it, I don't know exactly what it will say, October 17th, 2024, then the case will stand dismissed for want of prosecution.
Got it. All right. Thank you, Your Honor.
You bet. Good seeing you.
May I be dismissed, excused?
Excused, yes.
Thank you.
Bye. All right, next up is Roswell Square versus TWWS. Is Mr. Anton on?
Good afternoon, Your Honor.
Hey, Mr. Anton, how are you? It's been a while.
It's been a while. Good to see you.
Same. There you are. So this is one of these that's kind of stalled. You're still interested in doing things. What does that mean?
So right after the time that we filed suit, Your Honor, this is a breach of lease case. My client purchased a strip center that had a restaurant in it. The restaurant tenant, for reasons unknown, within a month or two after my client bought the strip center, the restaurant, which was the anchor tenant, stopped paying rent, went out of business. And so, of course, as Your Honor knows or may know, when you purchase real estate, the rent rolls are a significant part of the valuation of the business, of the real estate that you're buying. So my client wasn't getting warm and fuzzies about some of the information that they were provided by the seller. So I served some third-party discovery upon the seller, trying to figure out what was going on leading up to the closing on the transaction. And that third party, non-party, which is the seller, has not been forthcoming with the non-party request that I served. I served them in late July. They gave me 2 pieces of paper in late September as their response, which was not responsive at all. And so I, pursuant to 6.4, rule 6.4, I gave them, I think, until the end of this week to get me the stuff, or I'm going to file a motion to compel. But we need to get some information from that non-party prior to judgment being entered against the defendant, because once that happens, my compulsory discovery power, other than against the defendant, will be foreclosed upon. And so I need to ask Ms. Niles if we could be removed from this calendar so that I could finish up this post-judgment discovery. And she indicated that Your Honor wanted me to appear today and explain that to you. So
Right. I did. Several folks said, hey, could we just move this to another time? And if it was on for status, no is the answer, because now is the time we need to talk about it. So you want to try to pry out of the seller, the former strip center owner, more information that you think.
It just doesn't make any sense. And we think that there's got to be emails or correspondence showing some duress on the part of the tenant.
Right.
Predated the closing. And if that's the case, then we're going to have a conversation with the seller.
Right. And possibly other litigation. Do you have any discovery from the defendant in this case that would suggest that there was communication between the defendant and the former owner?
I do not. And the docket will reveal that the way that I was able to serve the LLC defendant was by way of statutory electronic overnight delivery, because they failed to maintain a registered office. The business was, they left and went to, I think they fled to Denver or Colorado. We've tried to find them. I can't find them. So the service that we had perfected upon the LLC was a statutory service, not actual personal service, because I can't find the guy that owns the LLC that went out of business. So to answer, no, I don't have any discovery from him. Once we get the discovery from the non-party, once we get a judgment, I suspect that the assistance of somebody out in Colorado, we can hopefully find this guy. But as it stands now, I can't find him.
Okay. So have you worked with Ms. Niles about getting a order to compel? Are you planning on filing a motion to compel as to the seller? What can we?
Yes, if I don't receive the information by my good faith attempt deadline of, I think, either Thursday or Friday, I will file a motion to compel against the non-party. And of course, as you know, that's 30 days. And so that they would need a response. They have been relatively friendly on the phone, but their document production demonstrates something different. So I don't know if this is going to be an adversarial situation. I do believe that the stonewalling that I'm getting kind of proves our suspicion, but maybe.
Yeah. Okay. So in terms of next steps, either you get everything you have asked for by the end of this week, or you'll file a motion to compel with a proposed order, not in the docket, the proposed order gets emailed to Ms. Niles, and I'll get that out the door, and that'll move things along. And yeah, they get 30 days, but to me, the issue isn't the 30 days. It's seeing that there are markers in place that ensure that something's happening. And I now better understand that you've been up against one, slow-moving third-party discovery and impossibility right now of discovery from the defendant, because who knows where that entity, that person really is. So that slows things down. But we can pick up the pace by either you extract from the seller that information, or the order compelling the production gets us something.
Yes, Your Honor.
Okay. Anything else that we ought to be thinking about in terms of assisting you in moving the case along? Or it's really, that's it. As far as you can see right now, it would be discovery from the seller.
Yeah, I mean, if I get everything that I'm supposed to get and there's no smoking gun, then we will simply file a motion for default judgment, because then the whole point of the discovery will have not revealed what we suspect is there. If it's not there,
yeah,
it's not to proceed with the default judgment.
Okay. Got it. What was the restaurant?
Actually, my client representative is online. Brad, I'm not sure what it was. It's called A Street, I think. Brad?
Yeah, A Street restaurant in Roswell, Georgia.
Okay, it wasn't a chain. It was a one-off.
Yeah, like a pop type thing. Yeah.
Chef-driven type restaurant.
Okay. All right. Well, Mr. Anton, thank you for plugging in and giving me that update. We will look for either a motion to compel, or if you get everything and you don't need my intervention, it could be that you're amending your complaint to paint a bigger picture, and we'll move it that way. And it sounds like the least positive outcome will be the motion for default judgment, which it sounds like would be forthcoming. And then good luck with that.
Thank you.
All right. Yes, sir. Thank you. Next is Itria Ventures versus Lorraine's Boutique and others.
Good afternoon, Your Honor. Paul Williams on behalf of Itria Ventures LLC.
Itria Ventures. Hello, Mr. Williams. How are you?
I am doing well, thank you. How about yourself, Your Honor?
I'm all right. Any reason to expect anyone from Lorraine's or Ms. Simmons to join us?
None that I'm aware of.
Okay. Let me know what's going on with the case. I think we're on for a pretty basic default judgment.
Yes, Your Honor. We filed a verified complaint in May. We're able to serve defendants almost immediately. The defendants did not respond to the complaint in any form. We filed a motion for default judgment for the liquidated amount of I believe it's $58,959.52. Submitted an affidavit in support of attorney's fees and prejudgment interest that was filed on August 11th. The prejudgment interest that was indicated as of August 11th was $1,232.50. We also, that amount has gone up. If you want an updated amount, I believe it's through today, it's $1,979.25. We submitted our billing records in support of the attorney's fees claim. The contract does provide for reasonable attorney's fees, and the total amount of attorney's fees was $1,682.50. That's primarily time by myself and paralegal on the matter. My billing rate in this matter was $275 an hour, which is a negotiated rate that's significantly less than my rack rate. And the paralegal's time was $200 an hour. We've also had expenses of $746.18, which was the filing fees, process server fees, and some additional research fees. So the total amount of attorney's fees and expenses is $2,428.68. Depending on whether you want an updated order or not, the order that we did submit a proposed judgment order reflecting the amounts that I just outlined, that was in the amount of $62,620.70. If you want it updated through today, it would be $63,367.45.
Because of the interest, the only thing that's changed is that interest figure you gave me?
Yes, Your Honor, because we had calculated it through the date that we filed the affidavit, which was August 11th, as opposed to today's date.
Got it. Okay. No, I wrote down that interest number and I've got the Word file, so I can take it from here.
All right.
Good. Well, that's it. Thank you, sir. I will get the order out today or tomorrow.
Thank you very much, Your Honor.
All right. Bye-bye.
All right. Bye-bye.
All right. Two cases left. Second to last is Winthrop Homeowners Association versus Jeffrey Scroggum.
Yes, Your Honor. My name is Andrew Mazingo. I'm here on behalf of plaintiff in this matter.
All right. Thanks for being here. So this is not the usual homeowners association default we get. I guess it's not that Mr. Scroggum isn't paying his annual assessments. It's that his yard doesn't look the way the homeowners association thinks it should look.
Well, Your Honor, not only does his yard not look the way that the association expects and the community expects, this owner actually hasn't made any payments to the association since 2019. So that also is at issue in this matter. The association is looking for both injunctive relief with regards to the numerous violations occurring at the property, and they're also looking for recovery of unliquidated damages, which is why my witness, Mr. Lee Jackson, I believe he's still on the call, is here to testify to the amounts that are owed as well.
Okay. So it would be damages and whatnot, and then ultimately equitable relief as well, that would make clear he needs to do these things, Mr. Scroggum, and if he doesn't, it would empower the homeowners association to engage in self-help.
Your Honor, the association doesn't believe that self-help would be an adequate remedy in this situation, and we've discussed this at length. The owner has a number of ongoing violations and hasn't made any payments to the association in over 4 years. We would be seeking more amounts if this owner had continued to not pay, and we filed any later than we have. This owner's ongoing violations won't be solved with self-help because the association won't be able to recover those amounts that it will be seeking from this owner. It would be incurring these costs, and the cost of bringing this property into compliance would be expensive. There's not only issues with the house itself, also issues with the yards, and there's issues with the driveway, all of which Mr. Jackson can testify to. However, not performing self-help onto these maintenance violations wouldn't correct the issue. We'll just be back here in another 6 months with you.
All right. Well, why don't I turn it over to you and your witness, and we'll hear what you have to say.
All right. Mr. Jackson, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
And can you please state your name for the record?
Lee Jackson.
And Mr. Jackson, what is your affiliation with the plaintiff Winthrop Homeowners Association?
I'm the property manager for the association.
And you're familiar with the defendant, Mr. Jeffrey S. Scroggum?
Yes.
And how do you know this owner, Mr. Jackson?
He's a homeowner within the community.
And your association has a routine practice for recording assessments, transactions with these homeowners?
Yes,
And you're familiar with the system and how it works?
correct.
Can you please describe that system?
Well, when we receive an assessment, when they become due, they are recorded on the ledger. And when payments are made either over the internet or by check, they are recorded upon receipt.
Your Honor, are you having any trouble hearing Mr. Jackson? I know I'm having a little bit of trouble on my end.
Towards the end there, when he was describing how the system worked, yes.
Okay, Mr. Jackson, is there any way we could maybe move the camera a little bit to see if we can hear you any better so we can explain that method for keeping transactions on the ledger?
Can you hear me now?
That's much better.
When payments are made either over the internet or by check, they are recorded upon receipt into that system.
And Your Honor, I have submitted to Miss Niles, I believe it is, in advance of the hearing, the exhibits that we intend to use. Just to be candid with the court, I did not submit that by the October 9th deadline. I was not aware of that deadline. However, I did send that before the hearing. So if that's okay, I can go ahead and share screen now and we can continue by trying to introduce these to the record.
Okay.
Thank you, Your Honor. All right, Mr. Jackson, is this account ledger made in the regular course of your company's business?
Yes.
And how did you become familiar with this document?
During my time as the association manager.
And there is another account ledger here. Are you also familiar with this account ledger?
Yes.
I am assuming that you've come into contact with that in your time as the association manager. Is that correct?
Correct.
Your Honor, if we could introduce these exhibits as Exhibit A, this is the association's account ledger that we'll be basing damages on today.
Okay.
And Mr. Jackson, based on this ledger, how much is owed by the defendant since 2019?
$1,960.
That's in principal assessments. What is the rate of interest that is accruing on the outstanding balance?
16% per annum.
Okay, and what is the amount of total interest that has been accrued on this owner's ledger?
$648.
And the administrative cost incurred by the association?
$165.
So I'm curious, maybe I'm looking at the wrong thing. The figure I heard Mr. Jackson state was relatively low. This homeowner transaction history, it's a balance of over $40,000 that's owed. What am I misreading?
Yes, Your Honor, you're not misreading anything. The majority of this account balance is in the violations that have occurred. Mr. Jackson, can you tell us if there's which violations those are that are ongoing?
The homeowner is not taking care of any of the landscaping as far as there's no grass to be replaced. They haven't maintained any of the bushes or trees in the front yard. We've asked for just painting and power washing the outside of the home, maintaining the driveway, and weather. So several things with the mailbox not being painted or a flag or things like that. So those are ongoing issues.
And the association has imposed fines for these violations. Is that correct?
Correct.
Did the association send this homeowner any prior notice of his ongoing violations, which led to these fines?
Yes.
And did the notices imposing fines include an opportunity for this homeowner to request a hearing before the board of directors?
That is correct.
And this owner did not request a hearing, is that correct?
No.
What is the rate of the association's fines that have been imposed against this owner?
It's $25 per day.
And this owner first received fines when?
The first fines were imposed on the 6th of 2019.
And have fines been imposed every day since August 6th of 2019?
There was a periodic delay between August 6th and August 30th of 2020, or
And the-
August 6th through, yes.
And did the association impose any fines during that year period?
2,100.
All right, and since this owner has been receiving fines at an amount of $25 per day, including that pause, how much of fines has this owner received from the association?
They have received a total of $30,200.
Can you say that again? I'm sorry, we didn't hear you correctly.
$30,200.
And these fines are imposed in order to convince homeowners to resolve their violations. Are any of these violations ongoing?
Yes, they're all ongoing.
All of them, including pressure washing, the landscaping, all the issues with the bare spots in the yard, all those?
That is correct.
In addition to those violations, has the owner made a single payment to the association in the past 4 years?
No, they have not.
And the association has incurred attorney's fees in order to send this homeowner violation notices, notices of lien, notices of the ongoing violations during this time?
Yes.
Your Honor, Mr. Jackson's testified to the amounts that are owed, but he's also testified to the ongoing violations and the fact that this owner has not responded to a single communication until, in fact, this weekend is the first time that we received any communication from this homeowner.
And what was the communication that you received?
This homeowner reached out to us and informed me that he had neglected his account. He asked that we reach out to him regarding an amount owed. I intend to inform this owner following the default hearing that the judgment amount we received is what we will be seeking from him, but I didn't want to tell him a total account balance until we received a judgment from Your Honor, so that we know the exact amounts that we're entitled to recover.
Okay. Mr. Jackson, do you have any concerns that Mr. Scroggum didn't know that he was doing things that were inconsistent with the covenants and the bylaws?
I mean, we send homeowners within the community the same. We do not only send it via mail when you get a violation, but we also send email, and those homeowners typically respond pretty quickly. And this homeowner is not responding at all, and has my contact information because he did reach out the other day for asking about this stuff. So I don't have a concern. I think he just, the way the property looked, it looked like he wasn't even living there actually. So.
Okay. But it's not, you're not worried that, oh, we're sending it to the wrong email address, or obviously the postal address is easy. It's, you know, the address, it's in the community. But it wasn't lack of communication on the HOA or property manager's part.
No, Your Honor.
Okay. All right, Mr. Mozingo, back to you.
Thank you, Your Honor. As you've heard from Mr. Jackson's testimony, this defendant is in debt to the association in the amount of $1,960 in assessments, interest in the amount of $648.28, fines in the amount of $32,200, administrative costs in the amount of $165. I can testify to the amount of attorney's fees and costs that have been incurred. I'm an attorney duly authorized to practice in the state of Georgia with the firm Luder, Larkin and Hunter, who has been reserved for counsel by the association since 2019. The association has been billed at an attorney rate of $230 per hour until 2021, $260 per hour thereafter, and an attorney collection paralegal rate of $130 per hour. It is in the regular course of business that we make and keep a billing record. and the entries appearing in the record were made at the time that they were billed. The legal services rendered to the association for the cost of collection of assessments and for the ongoing violations in pursuit of the covenant enforcement of that matter has been $8,420 and costs in the amount of $402.34. These amounts are customary in the Atlanta area for attorneys of the similar experience and expertise in this type of law. The hourly rates, work performed, time spent, and total expenses incurred for the legal services rendered are reasonable in light of the complexity and nature of the work. Your Honor, for the reasons I've stated, we respectfully request that a judgment is entered in the amount of $41,795.62. But more importantly, we request that the association is granted a order requiring this owner to abate the violations that we've discussed today, which include maintenance of the home, driveway, yard, bushes, and mailbox.
So I'm looking at your proposed order and it doesn't, I think, quite line up with some of the discussion we've had. Can you stop sharing your screen?
Yes, Your Honor.
Thanks. The numbers are fine. It's not that, but it's the equitable relief. So the first directive would be that Mr. Scroggum maintain the property by, and then it lists some things: pressure washing the home, trimming bushes. Then the second provision empowers the association to file a motion for contempt if he hasn't done these things. Then it prohibits Mr. Scroggum from interfering with your right, the association's right, to enter upon the property to do these things. I thought you said you didn't want the self-help part in there.
Yes, Your Honor, we do not want the self-help part. However, if there is any issue with granting the equitable relief, we did want to be able to have that as something to rely upon. The equitable relief is the concern of the association more so than anything else. We don't believe that that would be an adequate remedy, the self-help. However, that has been included as an alternative request to the request for self-help.
Okay, I mean, it's all equitable. For me to say that he has to let you, the association, go on his property, I don't mind doing it. If he's not going to paint the mismatched shutters, then the association can hire a contractor to do it, and he pays the cost of the contractor. I just thought you didn't want that, and yet it's in your proposed order. So you want that as a possible form of relief, but you are hopeful that the directive, hey, Mr. Scroggum, you need to do these things, gets you what you're trying to get done.
Yes, Your Honor, we would much prefer the equitable relief such that we can file a motion for contempt, because the association would only end up back in your court in the next 6 months, filing again to seek recovery of the self-help cost, and then again asking for equitable relief if this owner fails to correct the issue. The association would only continuously be in a cycle of performing self-help, allowing this homeowner to neglect his property, filing again, and for that reason, we don't see it as an adequate relief. However, we do include it as an alternative remedy if the motion for contempt order isn't accepted.
So when ordering a defendant to do something, it helps for it to be specific and unambiguous, so compliance can be confirmed and enforced if it needs to be. I worry a little bit with some of the language, pressure washing the home and driveway. I know what those words mean, but what if he pressure washes it and the homeowners association says, we don't like the job you did, but he says I pressure washed? Trimming the bushes, is it trimming them to within 3 inches of the windowsill, or is it getting rid of any branch that's 4 inches longer than the body of the bush? I'm worried a little bit that these are not specific enough directions that it's going to get messy for the homeowners association and Mr. Scroggum. They don't seem to be on great terms.
Yes, Your Honor, I can resubmit a proposed order that will include more definitive directions with regards to the driveway and home, it's that there's mildew and stains. And I believe I included that in the first definition of the violations. And then for brevity's sake, try to narrow it later on. I'll apologize for not continuing in being that, in being fully explanatory in that regard. In future, I will correct that. With regard to the maintenance violation of the trimming of the bushes and the yard, those ones are much more difficult for an association to describe with absolute particularity what the association expects. They are more lenient than 3 inches above, coming out with a ruler to decide whether someone's in compliance. What the association's governing documents allow for is the community-wide standard to dictate. So that is with regards to homeowners in the neighborhood and the standard that is prevalent throughout the neighborhood. If this homeowner was able to, show that all the homes in the neighborhood don't have sod in their yards, then that would be a way for us to, not be able to show that he's in violation. However, he's the only homeowner that I'm aware of, and any others that are in violation, we are pursuing for not having sod in large swaths of their yard, having hedges that are completely out of maintenance of the association's community standard.
Okay, well, I may tweak it a little bit. I just flag that as an area of possible future dispute, depending on how things go with Mr. Scroggum. But maybe now that he's decided to reach out to Mr. Jackson, this will all go smoothly. It doesn't sound like he's that kind of guy, but we'll see.
I will say one thing we do before we do file a motion for contempt is we will send an owner request or information saying, we will file this based on that violation. That way the homeowner's not caught off guard by us filing a motion for contempt. It's that they're aware and they can then reach out to us and we can discuss what needs to be done. So the expectations are fully communicated.
All right. Mr. Jackson, have you had a situation like this elsewhere in this homeowners association, or is this it?
Not of this magnitude.
Okay. All right. Well, good luck with it. Mr. Mozinga, anything else?
No, Your Honor, that's all from me today. Unless there's any questions of you, it was a pleasure being in your courtroom for the first time today.
Well, virtually, you did a great job. I will reach out if I've got other questions or concerns about the proposed order.
Thank you, Your Honor. Am I free to go?
Yes, you and Mr. Jackson are.
Thank you.
All right. Our final case on the calendar, I think, is Divinity Associates versus Ms. Nesbeth Aguila. Let's see who we've got here.
Steve Rising here for the plaintiff, Divinity Associates.
Hey, Mr. Rising, how are you?
I'm doing well. How are you, Judge McBurney?
All right. And ma'am, tell me how I should best say your last name.
Nesbeth Aguila.
All right. We are here because you, ma'am, are arguably in default. And I know we're going to talk about that some because you did file an answer. It may have been a little late, and we just need to talk about the best way to move forward. Whether or not you're in default, is this a case where the two parties have been talking about a way to resolve it, or are we still far apart? And I'll start with you, Mr. Rising.
Sure, thank you. We were in pre-litigation negotiations. My firm sent a demand letter back on February 1st of this year. Ms. Aguila and forgive me, I'm sorry, Ms. Nesbeth. Can I call you Ms. Nesbeth? That's a little easier for me to pronounce.
Sure.
Thank you. Ms. Nesbeth and I were very close to settling the case for approximately $4,000. To the point where I had sent her a settlement release and gave her very specific instructions on, it was very specific on how to make the payments. We agreed on a payment plan, turning over the keys, because this is obviously a lease situation. It included a lease termination provision. And maybe I should take just a step back to give you the full picture. This was a lease that was signed in October of 21, and it ran through September 30th of 2023. So it was a 24-month lease. Ms. Nesbeth fell on some hard times and had to shut her business down. And then that kind of brings us present day. We had the negotiations in February and March. At the end of March, I sent her an agreement to sign. We had tentatively agreed on a number, and then Ms. Nesbeth retained an attorney and continued to try to negotiate that number, which I did not believe was in good faith, and my client was not prepared to accept that amount. The release and lease termination documents were never signed by Ms. Nesbeth. And so there is no official settlement agreement at this point. And so we moved forward with litigation, filing lawsuit in June. And Ms. Nesbeth was served on June 12th. She was supposed to reply or answer and file her affirmative defenses by July 12th, which she failed to do. And then you know what, I'm realizing I'm way out in front of your question. I believe I answered it. We were negotiating, but we're pretty far apart based on the negotiation history.
Okay, and there was a lawyer involved, at least for a little while, with Ms. Nesbeth, but that person or that firm is not in the picture anymore, I think, because I think the answer that Ms. Nesbeth ultimately did file, I don't want to misspeak, I'm scrolling down, is pro se. It is. Okay. All right.
You're correct. And I confirmed with that attorney that he does not represent her, at least at the time we had direct communication. And I would defer to Ms. Nesbeth to let me know if she has an attorney at the present moment.
Okay. And tell me, I will get to Ms. Nesbeth in a minute, but tell me, Mr. Rising, why the answer that was filed just outside the 30-day window, but within the 45-day window, wouldn't be a scenario where Ms. Nesbeth can open as a matter of right.
So in my experience and understanding, I've always been under the impression that you have to pay certain court costs and file some sort of accompanying motion just to more so as a formality rather than as a necessary requirement in order to lift that default. And Ms. Nesbeth, in my opinion, to the best of my knowledge, did not do either of those things. If that is incorrect, then I would like to know that information and have that. So once the motion, I understand she did file the answer on July 19th. It was backdated for July 13th, the motion itself. And then when I filed the motion for default, because I did give her the remaining period of that, the total 45 days, so she could open as a matter of right. There was no other accompanying paperwork, no affidavit filed saying she did pay the court costs, no motion asking to lift the default as a matter of right pursuant to 9/11/55. And then so we're kind of here in an odd hybrid situation of 9/11/55A as a matter of right, but then also she didn't follow the correct procedures, and it might bleed into 9/11/55B.
Okay. Ms. Nesbeth, tell me what you want to share at this point about just the procedure we've been talking about, not about the lease or your ability to pay, because I'm right now just wanting to figure out, are we in, you actually got to sit through a lot of the hearings today. Are we in the posture where I certainly can hear from you about the amount of damages, but you've effectively admitted liability because you didn't timely answer? Or are we in a slightly different setting where maybe there's a reason to open the default that I should open the default so that you all can litigate it. And I'll punctuate that second option with, if you think that's in your best interest. I don't know enough about the lease and whatnot, but I'll just tell you from looking at the allegations, this is probably not a real complicated lawsuit if it does go. If there's a lease and you signed it and it has pretty clear obligations, unless there was some breach about which I haven't heard, where the landlord didn't provide air conditioning and they were supposed to, or something like that, you had to pay. And it sounds like that became difficult to impossible for you because of financial circumstances. That is an explanation. It's just not a legal defense. There was a contract and you needed to perform, and it became financially complicated for you to perform. And I share that only because we can go around and around for a while, but it may be in the end, it's a Pyrrhic victory for you because default is reopened, your answer is in, and then there's a motion for summary judgment filed, and lo and behold, you end up owing what is in the contract plus more attorney's fees because Divinity Associates has had to work more on the case through its lawyers and maybe more interest. But that's not where we are right now. I'd like to hear from you.
So when I filed, it was electronically, and there was some problems with the program accepting my file. So I tried numerous times, and I believe I entered that as evidence because I did try to file within the time frame that I had.
Okay. Tell me what you mean by there were issues electronically.
It wasn't accepting the documents that I was trying to submit. And then I had to call the court support in order to figure out what to do.
Okay. And was this on the 12th or the 13th?
I believe it was before.
Okay.
And all of this was included in an answer back to Steve Reisling. And so as far as
when you say an answer back, I'm sorry. When you say an answer back, what do you mean? In something that you filed ultimately with the lawsuit, or an email that you sent, Mr. Reisling?
No, with the lawsuit. Yeah, these were the documents that were attached to all of that.
Okay.
And so as far as the lease, I mean, I don't know. I don't know what to say about it. And so
What was your business? What were you?
Not accurate information. So I don't know what else to say about that.
Okay. What was the business you were operating in the space?
Well, I had to sublease the office because it became uninhabitable. And so I tried to get out of the lease before, and I spoke to, Divinity and Associates about it. And so, yeah, and I told him it wasn't going to work out. And he told me he was going to take me to court and nothing could change as far as the offices. And I couldn't find anyone that would stay there to deal with what was going on.
Okay. And when you say he, you were talking to he, this would have been someone.
The owner of Divinity Associates.
Okay. All right. Mr. Rising, is this a case where you believe that the damages are liquidated because it's simply the rent payments plus any acceleration or fees or whatnot?
Yeah, that's essentially it. It's the rent payments. It's the base rent. There's a 15% late charge that's assessed every month. And then there are, give me one moment, I have my calculations up here. And then there's interest that accrues on all delinquent amounts. And then we are seeking attorney's fees and costs under OCGA 13-6-11 based on the bad faith negotiations, essentially tentatively reaching terms and then completely backing out and trying to continue to negotiate once we at least had a number in place. So, and then, to speak a little more to those attorney's fees and bad faith actions, my client has received a number of documents in the mail on June 13th, 2023, July 11th of 23, and then recently again, just this past week. They indicate that there is it appears to be some sort of IRS form suggesting that there's been a cancellation of debt and requesting that my client sign it and turn over a W-9 payment. I do not understand why my client is receiving this. The federal government, the IRS, has no authority to cancel the debt. It just doesn't quite make sense. And I interpret it as an intent to mislead my client and escape from any payment of any delinquent amounts.
Okay. But what I'm hearing from, I think, both of you is that I've got in front of me the paperwork I need to work through as a threshold issue. Should Ms. Nesbeth Aguila be permitted to open the default? And if I conclude she should be, then we're all set. We've got a complaint and an answer, and we'll need to have a scheduling teleconference. If I conclude she shouldn't, for reasons that would be determined, maybe it was a technical default because she didn't pay costs or who knows what. I'll look at the law and, of course, be guided by the law. That's my job. But if I conclude that default should not be opened, then it sounds like it has been adequately pled as to what the liquidated damages are, and we could move forward that way. Is there more, Mr. Rising, you think I need from plaintiff's side before I turn to all those pleadings to decide first, am I opening the default? And if not, then what the default judgment should look like?
Yeah, I do want to respond to a pair of comments that Ms. Nesbeth just made a moment ago. She indicated that there was evidence attached to her answer, which demonstrates she had trouble filing the document. I would be sympathetic to that situation because I've had my own issues filing it. The system's not perfect. However, I just pulled up the answer that I downloaded from the server. I don't see any attachments to Ms. Nesbeth's answer and affirmative defenses. Additionally, these other comments about uninhabitability of the space. This is quite literally the first that I'm hearing about this. I
don't want to dive into that. I mean, This isn't the, I heard her say it as well, and there may be 1,000 good reasons why she said it. This isn't the right time. This is the right forum someday if we end up having a trial. But right now, we are in the very dry, technical, procedural posture of, was there a timely filed answer? Should I open default? And then we'll flow from there. So I don't want to get into a back and forth of, it was habitable. No, it wasn't. That's not what we'd be working through today.
Understood. Thank you, Your Honor. So with that, then I believe you do have all the information that plaintiff would like to present at this time.
Okay. And ma'am, is there more that you want to share with me that you think I ought to understand concerning this procedural piece we're working through? So it's not how nice was the building or not nice was the building, or habitable or not habitable. It's much more boring. And that is the timeliness of your answer and whether I ought to open the default. And if I don't, then what do the damages look like?
Well, I did speak to the clerk after numerous times of trying to put it in through Peach Court. And so I spoke to technical support, I spoke to the clerk, and I was finally able to get my documents in there. And it was after the time, after that matter, but my first attempts were within the time frame. And so as far as Steve Risen saying that I'm trying to mislead anyone, that is not what I'm trying to do at all. Our initial agreement, I did make a first payment towards that, but I didn't see the paperwork that he had together that he wanted that he wanted me to sign as far as agreeing to terminate the contract. I did not see that, and I did send this first payment before seeing that paperwork. Once I saw it, I did not agree with what it said. And that is when I did retain a firm to help me look over that. Yeah, and that's why the other attorney's name is in there, but I can't retain him fully. Yeah, but that's when he went to file and yeah.
Okay. Well, I understand that. And I also definitely understand that concept of retaining fully. You can get a little bit of help, but a lot of help costs a lot. Well, this has been helpful for me to hear from both sides. I'm going to take this under advisement and look over everything that has been filed. If I need more information, Ms. Niles will reach out to both of you so you know what I'm asking for. I may ask for it only from one side, but both sides will get to understand what my questions are. And if for some reason I need to hear from both of you, we can always pop on Zoom just like this so that I can get that additional information. Otherwise, I'll work through the legal issues and head in the direction that the law indicates I ought to head. So I appreciate your time. I'm sorry you guys were last on the list, but it was important to get through all the cases. Anything else, Mr. Rising, on behalf of your client?
You know, I did think of one other thing, Your Honor. Even if Miss Nesbitt, obtained some help in from the pleadings itself, just looking at them, her answer was dated July 13th. At that point, she was already outside of the period. And so if it took 6 days to try to get it filed, it would appear to me, based on what was filed, that she was already outside of the July 12th window to answer that complaint. But that's really it, Your Honor. And I appreciate your time and look forward to your ruling. Okay.
Ms. Nesbitt, anything else from you?
If you can please just look at the exhibits that are attached. Yeah, I would appreciate that because they are screenshots of me trying to do things timely, just like I've also tried to settle this matter before having to come here.
Right. No, I promise you, I will look. I don't just look at the first page of a document, but I'll look through all the things. I want to make sure I'm pulling up the case right now. We've got what you're talking about. So you're saying that it's exhibits attached to your answer?
Yes, it's attached to my answer, and it has the screenshots of the Peach Court.
Okay, so I'm looking at your answer. I think this is what Mr. Rising was saying as well. I've got it right here on the screen, and it doesn't have attachments. Was there something else you filed? There is. Ms. Niles is nodding her head. Is it the October 4th thing? Or it's the August 17th?
Is page 1 through 10, and it also has screenshots of my emails, my email account, as far as trying to correspond with support to get help with this.
Okay, I see. You filed something. Mr. Rising filed a motion for default judgment in August, and a couple of weeks later, you filed an objection or opposition to that motion for default judgment. That has the kinds of things you're describing attached to it. Some Peach Court records and notifications. So I will certainly look at those because that's all relevant to this discussion we're having about yes default, no default. So that's in there. It just, for future reference, it's not attached to your answer. If people go look at your answer.
Oh, okay. I'm sorry. I know my verbiage is not, technically correct with everything. But after having issues with Peach Court, I started going to the actual court to make sure that things were filed in person.
Got it. Okay. That makes sense. And I can look at that. It's all in the docket. Well, thank you both. I will get to work on this. And as I said, if I feel like I need more information, we'll reach out. Otherwise, I will take care of things.
Your Honor, if I may just address Ms. Nesbitt briefly, directly, please do send me a copy of those. You can email me a copy of anything you file in the future, because I don't believe I received that.
Access to these things?
So don't talk over each other, but I'm not sure, Mr. Rising, if I can see it in the docket, you should be able to see it in the docket.
I do now, and I will take responsibility for not checking the docket and pulling it sooner. However, it's just customary to always exchange and serve documents on the other party, and that's all I'm asking for the future. So please, I just ask that it please be emailed to me directly in the future, rather than relying on the system's automated notice delivery system.
You did.
Okay, and I do remember sending things out in the mail to you as well.
Yeah, well, I'm not going to get in the middle of that part. Technically, by e-filing it, if everyone has registered appropriately, it's getting to everyone else. But it never hurts, just as a courtesy, when you've e-filed something, shoot a courtesy copy to the lawyer or the party on the other side. And I'm confident Mr. Rising will do that. You've got the email address for Ms. Nesbitt Aguila.
I do, Your Honor.
All right, and I'm sure she can
And
get
I
you.
have his mailing address, like I mail the other documents. Thank you.
All right, thank you, everyone.
Thank you.